Hello, and thank you for joining. And now may I present EEOC's Brandolyn Bickner.
Hi, everyone. Thank you so much for joining the EEOC for our webinar, The Pregnant Workers Fairness Act, an overview for workers. Today, we're going to talk about the PWFA, a law that went into effect almost a year ago. I'm Brandolyn Bickner, and I'll be moderating today's webinar. And I'm also joined by two of my colleagues, and I'll let them introduce themselves.
Thanks, Brandolyn. My name is Ingrid Dietzfield, and I'm an attorney in the Office of Legal Counsel.
Hello, my name is Denisha James, and I am an attorney in the Office of Federal Operations.
And the three of us are going to go through a few slides that will explain the basics of the PWFA. And after that, we'll have time for a Q&A. I know some of you have already submitted questions, so we'll go through some of those. If you haven't submitted a question, please feel free to either put them in the Q&A feature in this Zoom. And if you're on our live stream on YouTube, please email your questions to newsroom@eeoc.gov. And just as a note, the questions that we're going to be able to answer today will be on the topic of the PWFA, but we won't be able to answer questions about specific personal scenarios. But before we begin, here's a quick video message from our EEOC Chair, Charlotte A. Burrows.
Hello, I'm Charlotte Burrows, Chair of the U.S. Equal Employment Opportunity Commission, or EEOC. The EEOC is a federal government agency that enforces civil rights laws that prohibit discrimination at work. I'm glad you could join us to learn more about the rights that workers have under the Pregnant Workers Fairness Act, or PWFA. The PWFA is an important new civil rights law that began protecting workers on June 27, 2023. Congress gave the EEOC responsibility to implement and enforce the PWFA. This new law promotes health, equal opportunity, and economic security for workers who are pregnant or who have given birth so that they can continue working safely. The PWFA protects employees and job applicants who have limitations that are related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. The law requires employers to provide workers with reasonable accommodations, that is, temporary changes at work or to job duties, unless doing so would cause the employer significant difficulty or significant expense. The EEOC issued a regulation to implement the PWFA. It provides workers with information about their legal rights and gives employers guidance on how to meet their responsibilities under this law. The EEOC wants to provide as much help as we can so that workers and those that support and assist them, like unions, healthcare providers, and advocates, truly understand workers' rights and what to do. That's why we're holding today's webinar. The EEOC also has other resources on our website to help, including answers to common questions, posters, and information for employers. The more you know, the better you can help protect your own rights or help others. And you can always call us if you need information or help at 1-800-669-4000. That's 1-800-669-4000. Thank you for joining us today. I'll now turn it over to my colleagues to begin the webinar.
Wonderful. All right, let's begin by talking about why there was a need for this law.
So the point of the law is to help workers affected by pregnancy, childbirth, or related medical conditions keep working safely. Too many workers were losing their jobs, made to go out on leave, or forced to work doing tasks that put their health or the health of their pregnancy at risk.
And from what I understand, the PWFA requires employers to make reasonable accommodations for workers' limitations. And are all employers required to do this?
So the law applies to employers where 15 or more employees. So no, not all, but many.
Okay, and just so everyone is on the same page with us, can you also define what a reasonable accommodation is?
Accommodations are changes to the work environment or how things are normally done.
Great. So employers have to give these accommodations for workers limitations. Can you also explain what that is?
A limitation can be a minor problem or something more serious. For example, it can be needing to avoid something in order to maintain your health or the health of your pregnancy. Or it can be attending healthcare appointments for pregnancy, childbirth, or related medical conditions. And we'll get into more details about limitations in a moment.
Do employers always have to give a worker an accommodation if they ask for one?
If the accommodation would cause an undue hardship, which means significant difficulty or expense, they do not need to provide the accommodation.
Okay, got it. I think we're all on the same page with the basics, but we'll be able to discuss all of these issues more in depth throughout the webinar. So this next slide, we're going to talk about limitations. Could you please begin by explaining what types of limitations could get a worker an accommodation under the PWFA?
Sure, Brandolyn. Limitations are physical or mental conditions related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. And basically, that means that limitations are a need or a problem related to pregnancy, childbirth, or related medical condition. A limitation can be minor or infrequent, and it doesn't need to be a serious condition. Some examples of limitations or problems that a pregnant worker may experience are morning sickness, migraines related to pregnancy, fatigue, an increased need to use the restroom, needing to drink water regularly, needing to stand or sit, or needing to limit lifting. A limitation can also be actions to maintain your health or the health of your pregnancy, like avoiding exposure to extreme heat, or running or standing or walking for long periods of time. A limitation can also be attending healthcare appointments for your pregnancy, for childbirth, or related medical condition, like prenatal visits. Pregnancy, childbirth, or related medical conditions do not have to be the only reason, the original reason, or even the main reason for the limitation. But it does have to be related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions.
Can you give me some examples of related medical conditions?
Sure. So related medical conditions can be things that happen to someone who is pregnant or going through childbirth. For example, high blood pressure, postpartum depression, lactation, a miscarriage, or gestational diabetes.
So let's talk about some examples of accommodations workers could get under the PWFA.
Yes, so a couple of examples of accommodations that are available under the PWFA are breaks, additional breaks, longer breaks, or more flexible breaks to drink water, eat, rest, or use the restroom. Changes to your uniform or dress code, or providing safety equipment that fits, or telework. It's important to remember that these are just a few examples. There are many possibilities about what may work for you in your workplace. But as was mentioned earlier at the start of the webinar, an employer does not have to give a reasonable accommodation if it will cause significant difficulty or expense, and that is an undue hardship.
Got it. All right. What if workers can no longer do all of their job duties because of their pregnancy, childbirth, or related medical condition, or if they can't do the main tasks in their job description?
So under the PWFA, a worker can get job duties suspended under certain circumstances. First, the worker's inability to do the job duties has to be temporary. It can't be permanent or indefinite. Second, the employee will be able to perform the job duties in the near future. And the amount of time that's considered in the near future can vary. For pregnancy, it's generally 40 weeks. Third, the temporary suspension can be reasonably accommodated, meaning that there's a way for the employer to help keep you working. I think this is easier to understand with an example. So let's say that there's a worker at a fulfillment center who's 3 months pregnant, has a job that regularly requires lifting boxes, that the employee has a lifting restriction of 10 pounds because of their pregnancy. Also, the employer has a light duty program for workers who are hurt on the job. So the need to stop the lifting of 20 pounds is temporary, and the employee will be able to do it when the pregnancy is over. The suspension of the job duty can be accommodated by the pregnant worker using the light duty program.
What if an employer doesn't have a light duty program?
So the employee may still be able to get an accommodation, because an accommodation can include changing the work rules. So even if the employer does not have a program, the employer may be able to accommodate the temporary suspension of the duties, for example, by only assigning items of 10 pounds or lighter to the employee and having other employees lifting the heavier items.
Okay, well, we spoke earlier about reasonable accommodations. Could someone take leave as an accommodation under the PWFA?
Absolutely. Leave can be a reasonable accommodation. The leave can be for medical appointments, including regular prenatal appointments, to recover from childbirth or recover from a miscarriage, or to receive healthcare treatment.
Does it have to be paid leave?
Usually no, but if the employer has a policy that the type of leave that the employer is using is normally paid, then it should be paid.
Got it. What if an employee has a right to leave under another law, like the Family Medical Leave Act? Some might know this as FMLA, or another state law.
So in those situations, the employee does not need a reasonable accommodation. If the employee had used up their leave, then they can ask for a reasonable accommodation of more leave. The employer has to grant it if the employee is qualified, unless it would cause the employer an undue hardship.
We've been talking about what accommodations workers might want, but what if an employer is trying to require an employee to take leave when they don't necessarily want to?
So as I mentioned earlier, one of the reasons that the PWFA was needed was because employers were sending employees out on leave instead of making accommodations that could keep them on the job. So requiring an employee to take leave when there's another reasonable accommodation that doesn't cause an undue hardship would violate the PWFA.
Let's talk about asking for a reasonable accommodation. Let's say I'm pregnant, I have morning sickness, and because of that, I want to start my work shift a little later. What should I do?
You have to ask for an accommodation.
Okay, and how would I go about doing that exactly?
And so you have to tell your employer two things to ask for an accommodation. First, you have to tell your employer that you have a limitation, which is a problem related to your pregnancy, childbirth, or related medical condition. And second, you have to tell your employer that you need a change at work due to your limitation. Now, you don't need to use any special words or phrases like PWFA, accommodation, limitation, request, or medical terms. And you don't need to make the request in writing or in any special form. It can be done by a brief conversation.
Okay, and you said that I need to tell my employer. Who exactly at work should I tell?
That's a great question. You can tell your supervisor or someone who usually directs your work. You can tell someone in human resources, or if your employer has a system, you can use that system.
All right, let's say I've done all that. Now, what happens after I ask for an accommodation?
Well, that depends. Sometimes, especially if the accommodation is an easy one, your employer can just grant it. And I can give an easy example to show what that means and what that would look like. A pregnant cashier that typically stands during her entire shift asks her team lead for a stool. So in asking the team lead for the stool, later in the day, the team lead provides the stool. That's an example of an accommodation, an easy accommodation provided to an employee. Now, in some instances, there may be a need to exchange more information, and this can be done through texting, talking, or through email. For example, a pregnant customer service representative has morning sickness and asks for a later start time for 2 months because she needs to be near a bathroom in the morning. Now, when she makes a request, her employer may grant the accommodation as she's requested, or the employer may want to know if it would also work for the employee to telework in the mornings so that she's closer to her own bathroom and then come in at noon. The exchange of information is called the interactive process, and it isn't a formal process. There aren't any required steps, and what the interactive process looks like will vary depending on your individual situation. In many instances, it may be quick, brief, and informal, kind of like my cashier example, but in other instances, it may require, again, more information to be exchanged. I can give you one more example of what the interactive process may look like. Let's say, for example, an employee works in an assembly plant. She's 5 weeks pregnant and knows it is important to stay hydrated during her pregnancy. She texts her supervisor saying she's pregnant, she needs to carry water with her, and she needs to use the bathroom more often. Her supervisor responds and explains to the employee that she can take breaks when needed, she can drink water when needed, and when she needs to do so, she should call for a substitute to replace her in the assembly plant while she does so. When you're identifying the right accommodation, and that isn't obvious, it's important to note that the interactive process may extend to a longer discussion, or your employer may follow up with you. Again, the interactive process is a chance for you and your employer to discuss different options and preferences.
Okay, thanks. That's really helpful. Let's talk documentation. Can an employer require information from my healthcare provider?
It depends. First, it's important to know that an employer doesn't have to get documentation from a healthcare provider to process your request for reasonable accommodation. The PWFA doesn't require documentation. However, an employer can seek documentation from a healthcare provider when it's reasonable to figure out if you're covered by the law and what kind of change that you need. When an employer can get documentation, they can only ask for enough to confirm that you have a problem related to pregnancy, childbirth, or related medical condition, and need a change at work because of that problem or limitation.
When is it not reasonable for an employer to ask for documentation?
So the PWFA rule sets out some examples of when it's not reasonable for your employer to ask for documentation. When your problem and the adjustment that you need are obvious, for example, when you're clearly pregnant, you confirmed that you are, and ask for a different size uniform. Or when the employer already has enough information. It's also not reasonable for your employer to ask for documentation when you're pregnant and the accommodation you're requesting is one of 4 simple accommodations. These are breaks to use the bathroom, or for eating or drinking, or to be able to carry and drink water, or to be able to sit if you've got a job that requires a lot of standing, or to stand if you have a job where there's a lot of sitting. Also, it wouldn't be reasonable for the employer to ask for documentation if the accommodation involves pumping at work or nursing during work hours. And that's in situations where perhaps you normally telework and the child is nearby or at home, or if you work in a facility that has on-site daycare. Lastly, if other employees who are not pregnant can get the same accommodation that you're requesting without providing documentation, then your employer should not be asking you for documentation.
What kind of documentation can my employer require?
So as noted on the previous slide, you only need to give your employer enough documentation for them to determine that you have a problem related to pregnancy, childbirth, or related medical condition, and that because of that problem, you need a change or adjustment at work.
And can my employer require that I see a doctor that they choose?
No.
Okay. And can my employer share any of my medical information with others?
No. So employers must keep your medical information confidential with certain exceptions, those with the need to know in order to make your accommodation or medical personnel, that type of thing. This protection comes from another law, the ADA, but it applies to employees seeking accommodations under the PWFA. So medical information, like the fact that you are pregnant or have a medical condition that's related to pregnancy or childbirth, that your employer may get through the PWFA accommodation process, that needs to be kept confidential.
Okay, got it. Are there times when my employer can say no to an accommodation that I'm asking for?
Well, an employer does not have to provide an accommodation if it causes an undue hardship. And as we talked about earlier, that means a significant difficulty or expense. Also, it's important to note that if there is more than one accommodation that will work, an employer can choose between the accommodations. The employer does not have to give you the accommodation you ask for as long as the one the employer gives you meets your needs.
Got it. Thank you. That's really helpful. So I imagine a lot of workers might be a little nervous about asking for accommodations. Maybe they think they'll be, punished in some way or their employer will be annoyed. What does the PWFA say about this?
So the PWFA addresses this scenario, and the PWFA specifically addresses retaliation. Now, retaliating against someone, for example, taking their shifts, cutting their hours, giving them worse assignments, or disciplining them because they ask for or use an accommodation is against the law. That's something that is explicitly addressed in the PWFA.
All right. I think I have the basics down now. I've heard that I can get an accommodation for a limitation related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless it would cause an undue hardship for my employer. Let's turn to the Q&A portion of this webinar. I know we have some questions that attendees have already submitted, so we can go through some of those in a minute. But if you have questions today that we haven't answered already, please feel free to submit them through the Q&A feature if you're on our Zoom call, or to newsroom@eeoc.gov if you're on our live stream on YouTube. And I think while we wait for some folks to submit their questions, we can go through some frequently asked questions, and I'll ask those. So the first one that we hear a lot is, let's say I've asked for an accommodation, but my employer is dragging their feet. They aren't getting back to me. What should I do?
So first, check back with your employer and see when they think they'll be able to reply to your request. You can also ask your employer for an interim accommodation, and that means something that meets your limitation that you can do while you're waiting for the employer to respond. And you can remind your employer that providing an interim accommodation can be helpful to both of you. For example, let's say that there's a pregnant warehouse worker tells her supervisor that she can't lift, push, or pull more than 25 pounds for the rest of her pregnancy for the next 6 months. After talking further and exploring different options, the supervisor finds equipment that the employee can use to move the boxes. The equipment, however, needs to be ordered, and it can't be delivered for 3 weeks. As an interim accommodation, the employee rather, is assigned to light duty until the equipment arrives. Also keep in mind that if your employer unnecessarily delays your accommodation, it could be a violation of the law.
Okay, got it. Let's say that I can do my job just fine, but my employer is insisting that because I'm pregnant, I have to stop certain duties or I have to take leave. Is that okay?
So this is not allowed. An employer cannot require you to accept a reasonable accommodation that wasn't reached through the interactive process. And an employer can't require you to take leave if there's a reasonable accommodation that would let you keep working.
Another question that we frequently hear is, I look visibly pregnant. I interviewed for a job and the interviewer asked me how much leave I would need after having my baby. And after hearing my answer, they didn't hire me. Is there anything I can do in that scenario?
So this could be a violation of the PWFA. An employer can't deny you opportunities like a job because you may need a reasonable accommodation. This could also violate other laws against pregnancy discrimination.
All right, and last question. Let's say I want to pump at work or nurse during the workday. Does the PWFA say anything about those topics?
Yes, it does. Under the PWFA, you can get an accommodation in order to pump at work or nurse during the workday when your regular workplace is close to your child. For example, if you work at home and your child is there, or if your child is at a nearby daycare center. The PUMP Act is enforced by the Department of Labor and also provides the rights for most employees to pump at work for up to 1 year after the child's birth. And you can learn more about the PUMP Act at the Department of Labor's website. We have included for you today, or we'll be providing the link to the Department of Labor's information page, which outlines protections to pump at work.
Got it. Thank you so much for answering some of those frequently asked questions. Let's see what questions our attendees have asked. Like I said, some of these questions are live and some are questions that we've received in advance. So let me just pull those up quickly. All right. Our first question is, does the PWFA define reasonable accommodation as defined under the ADA?
I guess I could take that one. So under the PWFA, it does borrow language and terminology and some concepts from the ADA, but with the PWFA, a lot of the problems or limitations can be modest and minor. And so they can also be temporary. I'm sorry, will you repeat the question? Lost my train of thought there.
Yes, no problem. Does the PWFA define reasonable accommodation as defined under the ADA?
Right. So it is just a change in the way things are normally done. It can be a change in the workplace environment. So it will always obviously depend on your particular circumstances as to what accommodation may be effective. And what's sort of unique to the PWFA is that there, in some circumstances, you may have an essential function temporarily suspended.
All right, let me check our next question here. Sorry, just one moment. My computer froze. All right, here, I have them up. All right, another question we have, can my spouse get leave under the PWFA to come with me to medical appointments?
So Brandon, this is a question we get a lot. The answer is no. The PWFA only provides for accommodations for the person with the limitation related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. So it would not cover a spouse.
Okay, got it. Thank you. Another question we have here, under the PWFA, can a reasonable accommodation be that my employer covers something through health insurance?
So no, that the PWFA doesn't require that as an accommodation, certain items would be covered. In fact, it explicitly provides that that certain treatments or procedures cannot be made to be required under a health plan.
Okay, got it. Another question we have is, do I need to have worked for my employer for a certain amount of time in order to get a reasonable accommodation under the PWFA?
No, the PWFA does not require that a worker have worked for a specific employer for a certain amount of time. And it's also important to note that the PWFA also applies to applicants as well.
Thank you for that answer, Denisha.
No problem.
Let's see, let's find another question. When my pregnancy started, I needed more breaks and my employer gave me those additional breaks. Now I need help lifting. What should I do? Okay, so their employer gave them an accommodation, but now they need perhaps an additional accommodation. What should they do?
And I think that that's very common, that as a pregnancy advances, that there are different changes and different needs and perhaps different accommodations. So it's fine to ask for a new or different accommodation, and for your employer to use that interactive process that Denisha talked about in order to get the right information and help identify, a new, effective, or modified accommodation. Again, unless it would cause the employer an undue hardship, which is a significant difficulty or expense.
Thanks, Ingrid. Another question here. I have a disability and have an accommodation for that. What happens if I'm pregnant and need something else or something different? So kind of a similar question to the last one, but slightly different here.
No, I like that. I like questions that sort of bring the separate laws together. Under the PWFA, you can get additional or different accommodations for your problem. Of course, if the problem is related to, affected by, or arising out of pregnancy. And this is true even if you already have an accommodation for your disability, which would have been provided for you under the ADA. So one example I can think of is a worker who has diabetes, and her employer has provided her with an accommodation of breaks to eat small meals throughout the day and breaks to check her insulin levels. When she becomes pregnant, she then experiences morning sickness. That makes it difficult for her to eat in the morning. As a result, she needs breaks for eating later in the day and occasionally needs a break to rest while at work. Now, it's important to note that the PWFA does not take away any rights a worker may have under another law. So for example, if there's a state law that provides more rights to the PWFA, the worker still has those rights. And of course, as we've discussed, the employer does not have to provide the accommodation under the PWA if it causes an undue hardship. But in my example with the worker with diabetes, you see where the worker is is able to receive an accommodation of the ADA as well as the PWFA once she becomes pregnant. And one certainly doesn't nullify another. So.
Thank you. Thanks for explaining the details there. Another question we have here, can I get an accommodation to attend a healthcare appointment?
Yes. So under the PWFA, one of the reasons for an accommodation may be that you need to attend a healthcare appointment. You can get accommodations for maintaining your health and the health of your pregnancy.
Got it. All right. Another question we have here. My employer denied my request for an accommodation, saying that it would be an undue hardship. What should I do next? What does this mean exactly?
Good question. So even if you are entitled to a reasonable accommodation under the PWFA, if your employer can show that the specific accommodation you requested would impose a significant difficulty or expense on their business, they can lawfully deny it. However, just because one accommodation imposes an undue hardship, that doesn't mean that you are entitled to an accommodation of some other type. For example, if you requested full-time telework as an accommodation and your employer is able to establish that providing you with full-time telework would impose a significant difficulty or expense on their business, you may still be able to get a different accommodation, such as telework 2 days a week and additional breaks while you're in the office. If your requested accommodation is denied because of undue hardship, you should ask your employer about alternative accommodations. You can also ask them why or how the requested accommodation imposes a significant difficulty, because it's up to the employer to prove that an undue hardship exists.
Thanks for that answer, Denisha. We have another question here. My pregnancy isn't showing yet. Could I ask, or could my boss ask to see a pregnancy test if I request an accommodation?
So no, your employer can't require a pregnancy test. In fact, your employer doesn't need to seek any supporting documentation when you ask for an accommodation. Your employer can seek supporting documentation from your healthcare provider if you ask for an accommodation and it's reasonable under the circumstances. So if you're pregnant and not showing yet, it isn't reasonable if you're trying to get one of those 4 simple accommodations that I mentioned earlier: breaks to use the bathroom, breaks to eat and drink, to carry water with you, sitting if your job requires standing, or standing if your job requires sitting. If you're seeking a different accommodation, will depend on the circumstances, but your employer can ask you for supporting documentation.
Thanks for the answer, Ingrid. Let's see. I have another question. Under the PWFA, can an employee get an accommodation of full-time telework so that they can nurse their baby?
Well, the answer to that question is it depends. The PWFA requires covered entities to provide reasonable accommodations to the known limitations related to affected by or arising out of pregnancy, childbirth, or related medical conditions of qualified employees, absent undue hardship. Now, you can ask for an accommodation of teleworking so that you can nurse, but if working in the office and having time to pump would work for you, the employer may offer that instead, and that would be sufficient under the PWFA. I know I mentioned this before, but I think it's helpful to mention it again. You're not entitled to the exact accommodation that you request, but it does have to meet your needs. So in this example, you aren't entitled to the telework for nursing just because it's your preference. But if once the employer provides you with an accommodation that meets your needs, they've met the requirements on WFA.
Okay, thank you for that answer. And I just got a time mark, so I think we have time for one more question, which I have here. If I think I have been discriminated against and I call the EEOC, what will happen? So maybe what's the process here?
So it will depend, but generally you can fill out a form and submit an inquiry and make an appointment on our website. If you decide to file a charge, we will let your employer know about it and conduct an investigation. We may also ask you and the employer if you want to attend voluntary mediation. And there's more detailed information available on our website, and we're going to put all that information. We'll put a link in the chat, and there'll be some more resources on the closing slides.
Got it. Thank you both for answering those questions. That was very helpful, and I'm sure it was helpful to our audience as well. So let's just talk about a few key takeaways, and then we can move on to some resources for anyone in attendance. Ingrid, do you want to talk about some key takeaways that you want our watchers to take away from this webinar?
Absolutely. I think one of the most important is just to understand that under the PWFA, an employer must make reasonable accommodations to an employee or applicant's known limitations related to pregnancy, childbirth, and related medical conditions, unless it would cause an undue hardship. And I know that's a mouthful. There's a lot of legal terms in there. But reasonable accommodation is, remember, we talked about it's a change in the work environment or the way that things are normally done. And under the PWFA, this can include temporarily suspending certain job duties. It also can include things like leave. And remember, an undue hardship is significant difficulty or expense. And also that this law applies to employers that have 15 or more employees.
Got it. Denisha, do you have any key takeaways that you want to share with the group?
Of course, of course. I think that it's important to remember what a known limitation is. A known limitation is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. And remember, these can be problems that are modest or minor. It can be a need to maintain your health or the health of your pregnancy. And the limitation can also be seeking health care for the pregnancy, childbirth, or related medical conditions. I also think it's important to remember that you have to ask for an accommodation by telling your employer two things. You have a limitation and you need an adjustment or change to work due to that limitation. And lastly, it's important to remember that your employer does not have to give you the exact accommodation you request, but unless it causes an undue hardship, your employer does have to give you an accommodation that meets your needs. So with that, Brandon, I'll turn it back over to you.
Thank you. Thank you both. All right. Our last slide is really just a list of resources. You could keep going, just one more slide. There you go. And on this slide, you'll see a list of links, helpful resources, including how to contact the EEOC. So feel free to write these down or take a picture of what's listed here. There's also a QR code that you can scan with your phone. That will take you to a what you should know about the PWFA page on our EEOC website. I know there were a lot of questions in the Q&A. We weren't able to get to everything, but I think a lot of these resources will answer questions that you have. And so we'll leave this slide up as folks exit the webinar. But otherwise, I want to give a big thank you to our speakers and to our attendees. And we hope this webinar was very helpful for you.